Today I'm excited to be sharing a demonstration of Litigation Labs, a trial advocacy simulator where lawyers and law students conduct direct and cross-examination, argue objections, and handle exhibits in real time. The judge, opposing counsel, and witnesses are played by AI agents. Think of Litigation Labs as a boxing gym for lawyers. This is where you go to spar, to sharpen your skills before stepping into the courtroom. Our product has 4 stages. Users start by uploading any type of file. It could be a mock trial packet, summary judgment materials, or other trial documents. Our system then transforms those files into a fully customizable trial scenario, which gets played in the case simulator. Users can then test their trial theories, refine examination outlines, and sharpen their trial skills against our AI agents. After each session, users review the full transcript, including objections, rulings, and key examination turning points. This is the Litigation Labs case library. You can see folders for different cases. Each one holds the source documents and the scenarios I've generated. This is the folder for Rivera v. Thornton, a mock trial problem based on a straightforward civil negligence case. Clicking Create Scenario transforms the packet into a fully playable trial. The scenario generator reads each document and maps key testimony to each side's positions. The output is fully editable before anything is published to the case simulator. Users can also upload their own examination outlines to work from during simulation and to refine over multiple sessions. Litigation Labs is designed with instructors in mind. From the library, scenarios can be assigned to students for practice. No coordinating schedules, recruiting volunteers, or booking courtrooms. And students can practice as many times as they want. Once we're ready, we can pick a side. Let's start playing as plaintiff's counsel. The trial starts after the judge calls the case. We begin with direct examination of our first witness, a male man named Jordan Blake who witnessed the car accident while walking his route. On the right is the courtroom, rendered as a live trial transcript. On the left is the user's desk. Everything they may need during trial is kept here. I'll start with a few background questions like name and occupation before getting into the events in question. Witnesses only answer from their uploaded statements. They don't hallucinate, and if they don't know the answer to a question, they say so. Let's see what happens when the user asks a question that violates the rules of evidence. Here I am asking a leading question on direct examination. And as we can see here, opposing counsel has objected on the grounds that my question is leading. For each objection raised by opposing counsel, users have 3 choices. They can withdraw their question, argue the objection lacks merit, for instance because an exception applies, or stand firm and proceed to a ruling. Once I choose how to respond, the judge rules, in this case correctly sustaining opposing counsel's objection. Let's take a look at another example. After the collision, another pedestrian told Jordan Blake, the mail carrier, that she saw the defendant's SUV run a red light before crashing into the plaintiff. As plaintiff's attorney, I would love to get that testimony into evidence. So I ask Mr. Blake to repeat what the pedestrian said to him. But as you can see, opposing counsel has objected on the grounds that my question calls for apparent hearsay testimony. The judge sustains the objection because the pedestrian's statement was made out of court, and I'm attempting to offer it for the truth, without any applicable hearsay exclusion. Now that we've completed direct examination of the plaintiff's only witness, let's take a look at the next stage of the trial, opposing counsel's cross-examination. In a real courtroom, opposing counsel doesn't always ask clean questions. Litigation Labs models that behavior. A preset percentage of opposing counsel's questions are intentionally designed to elicit an objection by the user. This is the rare environment where you can get serious objection reps without a real case on the line. The judge's rulings are also context-aware. Here, I object to a leading question. But of course,